Yeah, absolutely. Absolutely.
Good morning, everyone. And thank you for being here. This is an honor today, and I have a privilege to present this seminar, which is organized within the framework of a Jean Monnet network, LOTITIP, which is coordinated by the University of Bologna and run together with King's College London and the Université de Rennes of France. Basically, this is a network which has been created between three different research centers, university research centers, in order to analyze the legal implications of the conclusion and implementation by the European Union of free trade agreements of new generation. So the mega agreements the Union is negotiating and concluding with third countries. And within this big project, several activities have been realized and provided. This is one of them, so it's a seminar which is realized by University of Bologna. And I'm very pleased, and I thank him very much for having accepted my invitation, actually. I'm very pleased to have with us Judge Christopher Weider, who is Judge of European Court of Justice. Judge Weider holds a law degree from the Cambridge University, UK, and he has a very distinguished experience as a barrister in the UK, as a QC, and as a bencher of Gray's Inn, and also as a recorder of the Crown Court. He was appointed as Judge of European Court of Justice in 2012. And today, Judge Weider will give us a speech concerning the principle of autonomy of European Union legal order through the lens represented by a recent judgment delivered by the court, by the Grand Chamber of the court, the Achmea judgment, which is related to the dispute settlement mechanism incorporated into a bilateral investment treaty concluded between the Netherlands and the Slovak Republic, and its consistency with EU law, with the obligations from EU law. This is a very relevant judgment, I would say. I would like only to read 2 points of this judgment. I'm sure that these points will be discussed later on by Judge Weider, but just to give you, an idea of the importance of this judgment of the court, there is a point 34 of this judgment, where the court says that EU law is based on the fundamental premise that each member state shares with all the other member states and recognizes that they share with it a set of common values on which the EU is founded, as stated in Article 2 TU. That premise, so the sharing of those fundamental values among states, implies and justifies the existence of a mutual trust between the member states, that those values will be recognized, and therefore that the law of the European Union that implements them will be respected. And it is precisely in that context that the member states are obliged, by reason inter alia of the principle of sincere cooperation, to ensure in their respective territories the application of and the respect for EU law. So basically here the court is saying that the principle of sincere cooperation, and my students, I think, know that principle very well, represents a veritable cornerstone to ensure the protection of fundamental values of the European Union and the autonomy, in turn, of EU legal order. And in order to ensure that, the specific characteristics and the autonomy of EU legal order are preserved. So in order to ensure that this autonomy is preserved, The treaties have established a judicial system intended to ensure consistency and uniformity in the interpretation of EU law. So it is for the European Court of Justice, according to its mandate under Article 19 TU, to make sure that the principle of sincere cooperation will be triggered to preserve the autonomy and the unity of this legal order. So it's a very important ruling given by the Court of Justice in order to, let's say, fix the autonomy, I would say the borders of the EU legal order, and that's why I'm particularly pleased to have a judge with us explaining the line of reasoning of the court and the rationale behind this judgment. And I also know that probably at the end of his speech, Judge Vaida will be available for some questions, also concerning other cases. You know that in these last weeks, the European Court of Justice has decided many important issues, I would say many sensitive issues, so you are also free to pose questions concerning the other cases recently decided by the court. But without further delay, and again, many thanks for having accepted this invitation, I give the floor to Judge Vaida.
Thank you very much, Professor Casolari, for those kind words. I am delighted, indeed privileged, to give this speech at what I believe to be the eldest university in Europe, founded, if one can believe Google, but it was confirmed last night over dinner, so I think the date is correct, 1088, which is over 100 years earlier than my own university, the University of Cambridge, which was an arriviste founded only in 1209. And it gives me particular pleasure. Is that better? Can you hear me? Yeah. It gives me particular pleasure to be here because this is not only a university that has a proud history, but is a university that is at the cutting edge of European law today. It's from this university that the former Italian Advocate General Paolo Mangozzi came to Luxembourg, and the current Italian judge, Professor Lucia Rossi, who was sworn in October, also comes from this university. And indeed, I notice on this piece of paper here that she is still down as one of the coordinators of this program. Now, what I propose to do is to talk to you about the concept of autonomy in EU law, and in particular how it was applied in the case of ACME. This may be regarded as somewhat of a poisoned chalice, given that a recent editorial in the European Law Review, commenting on the ACME case, used the title, "But seriously, what is the principle of autonomy really about?" What I propose to do this morning is to begin by looking at the origin or roots of the use of autonomy in the case law of the Court of Justice before turning to the ACME case itself. At a general level, autonomy, which comes from the Greek, is understood linguistically as a body that has its own laws. It refers to the right or condition of self-government of a state, community, or institution. So it is independent and free from external control or influence. The notion of the EU as a self-governing institution, which is free from external control or influence, can clearly be traced back to the early days of the Union. Already in 1956, the first Advocate General Lagrange, referred to the autonomous nature of law arising from the treaties. And the seminal early cases of the court, which I'm sure you now are familiar with, Van Gent en Loos, Koster en NL, and International Handelsgesellschaft, have as their common point of departure that EU law, unlike international law, is normatively independent from the domestic legal systems of the member states. So it is autonomous from national law. However, the autonomy of EU law not only has an internal component, but an external component, i.e. it is autonomous vis-à-vis international law as well. The cases of Van Gent, Koster, and International Handelsgesellschaft largely confirm the internal autonomy of the EU. Other cases confirm its external element. Thus, in the international fruit case, the court laid down what criteria would be required as to when international law, in that case World Trade Organization rules, can be relied on to challenge offending principles of EU law. The fact that there are such criteria indicate that EU law can in certain respects to be understood as being insulated and thus autonomous from international law. And this emerged, in my view, very clearly from the opinion of Advocate General Maduro in the famous Cardi 1 case, and I will quote what he said. Although the court takes great care to respect the obligations that are incumbent on the community by virtue of international law, it seeks first and foremost to preserve the constitutional framework created by the treaty. Thus, it would be wrong to conclude that once the community is bound by a rule of international law, the community courts must bow to that rule with complete acquiescence and apply it unconditionally in the community legal order. The relationship between international law and the community legal order is governed by the community legal order itself, and international law can permeate that legal order only under the conditions set by the constitutional principles of the community. So that is what I call normative autonomy, that is to say, autonomous both from domestic law and international law. I'm now going to look at what I call institutional and jurisdictional autonomy. And as I say, I think when one talks about autonomy, it is helpful to separate these three concepts out. So dealing first of all with normative autonomy, this refers, in my view, to the principle that EU law is normatively independent vis-à-vis both domestic and international law. EU law claims a normative force which is independent from those legal orders. Its validity does not stem from those legal orders. So that's the first form of autonomy, normative autonomy. The second form of autonomy is what I would call institutional autonomy. The EU treaties provide for an allocation of defined responsibilities, like the delimitation of the respective spheres of competence of the EU and the member states, which lie at the heart of the institutional framework of the Union. The autonomy of the legal order requires this allocation of responsibilities or balance to be respected, and I'll come back to that. The third form of autonomy is what I call jurisdictional autonomy. This sense of autonomy amounts to the principle that, and I quote, the Court of Justice has exclusive jurisdiction over the definitive interpretation of EU law. That quote comes from the opinion 213 on the accession of the EU to the European Convention on Human Rights. The corollary of that principle is that the Court of Justice must be in a position to exercise that exclusive jurisdiction, which means that the questions of EU law must fall within the jurisdiction of a national court, which can then make a reference to the European Court under Article 267. That is the preliminary reference procedure. And I will come back to the consequence of that again, because that also lies at the heart of the Achmea case. Now, I want to say a little bit, as I indicated, on institutional autonomy. Again, going back to the Advocate General Lagrange in 1956, he laid down the principle of institutional autonomy in this way, and I quote, "Each institution within the limits of its powers is fully autonomous and cannot be subject to the authority of any other. It exercises its powers spontaneously and directly under the conditions laid down by the treaty, with the court appearing in this connection as the body responsible for regulating the respective spheres of authority." It is not difficult to see the seeds of autonomy, both in its institutional and jurisdictional sense, planted in this passage. Not only does it stress a sense of autonomy of the Union by reference to the function of the institutions, but it also incorporates the role of the court as the overseer of those functions. So these are the basic principles that underpin what I call institutional and jurisdictional autonomy. Second, and this follows from that above passage, institutional autonomy and jurisdictional autonomy are not hermetically sealed categories of autonomy. They shade into one another. The court is an institution of the EU. A violation of the jurisdictional autonomy of the court can therefore be understood as a violation of the institutional autonomy of the EU, and its jurisdiction extends to resolving institutional disputes. A violation of the institutional autonomy of the EU by, for example, a dispute resolution mechanism, what I will call a DRM, that could determine the allocation of responsibilities under the treaty and could therefore lead to a violation of the jurisdictional autonomy of the EU. This form of interrelationship is highlighted in the Cardi 1 case, and I'm now going to refer not to the opinion of the Advocate General, but to what the court said at paragraph 282. It is also to be recalled that an international agreement cannot affect the allocation of powers fixed by the treaties, or consequently, the autonomy of the Union legal system, observance of which is ensured by the court by virtue of the exclusive jurisdiction conferred on it by Article 344 of the treaty, jurisdiction that the court has moreover already held to form part of that very foundation of the community. Nevertheless, it is in my view helpful to distinguish between the two forms of autonomy to form a better understanding of what the autonomy of EU law is really about. As will become clear, I hope, there is one sense of autonomy that requires the specific institutional features of the EU, such as the relationship between the member states and division of competence between the EU and the member states, to be preserved, and another that requires the exclusive jurisdiction of the court to be upheld. Such a distinction between autonomy in its jurisdictional and institutional form is reflected in the case law, which often explains the principle of autonomy as requiring first the preservation of the essential powers of the community and its institution, and secondly, that a particular dispute resolution mechanism will not have the effect of binding the community and institutions to a particular interpretation of community law. Now, I'm going to look at that through the prism of two seminal cases concerning accession to international courts by the EU. The first is quite an old case, but is still a good law, an important case, is the Opinion 1 of 91. And that was where the Court of Justice my predecessors were asked to rule as to whether the proposed European Economic Area, EEA Court, was compatible with EU law. The EEA Court was designed to supervise the European Free Trade Agreement, EFTA, which sought to create a European Economic Area in the states who were members to that agreement. The rules which were to apply in the EEA covered the free movement of goods, persons, services, capital, competition, and were for the most part identical to those contained in the EU treaties. Due to the overlap between those rules, the EEA agreement sought to ensure the consistent interpretation of the agreement and EU treaties, a concept referred to as homogeneity. The keystone of that homogeneity was to be found in Article 6 of the proposed agreement, which provided that the provisions of EFTA are to be interpreted in conformity with the rulings of the Court of Justice on the corresponding provisions of EU treaties and measures of community secondary legislation which were given prior to the date of the signature of the agreement. Regarding institutional autonomy, the contracting parties could bring cases before the EEA Court, and that involved not just members of the EFTA but not member states, for example Norway, but also member states not part of EFTA, namely France. However, it was up to the EEA Court to determine what was meant by contracting party. The result was that the EEA Court would rule on the respective competencies of the community and member states as regards the matters governed by the provisions of the agreement. Regarding jurisdictional autonomy, the principal bone of contention was that the EFTA sought the homogeneous interpretation of the identical worded EU rules and EEA rules without providing for a sufficient guarantee that the EU institutions would not be bound by the EEA's court's interpretation of EEA rules. And as I said, all EU member states were also parties to the EFTA court. In a section dedicated to considering, and I quote, whether the proposed system of courts may undermine the autonomy of the Union legal order in pursuing its own particular objectives, the Court of Justice held that this had the effect of introducing into the community legal order a large body of legal rules which is juxtaposed to a corpus of identically worded community rules. The object of homogeneity between the identically worded provisions of the EFTA and the EU treaties would therefore prejudice the Court of Justice exclusive jurisdiction to determine the interpretation of the provisions of EU law. And it was on that basis that that proposed court was incompatible with the principle of autonomy of EU law. I now pass to a much more recent case, Opinion 213, which concerned the legality of accession of the EU to the Strasbourg Convention, the Convention on Human Rights, which is contemplated in the Treaty of Lisbon. The court held that this draft agreement was unlawful, and what I wish to focus on briefly is the issues of jurisdictional and institutional autonomy. First, the court explained that by virtue of the principle of mutual trust that Professor Casellari referred to in his introduction, the member states may be required to presume that fundamental rights have been observed by other member states. In such situations, the member states cannot check whether other member states have actually, in a specific case, observed the fundamental rights guaranteed by the EU. This particular feature of EU law and its consequences for the relationship between the member states was not taken into account by the draft agreement, which treats the EU like another state without regard to the extrinsic nature of the EU. So the accession agreement was therefore liable to upset the balance of the EU and undermine the autonomy, the institutional autonomy of EU law, and therefore unlawful. There were further problems in relation to institutional autonomy. At a level of generality, that mechanism, the co-respondent mechanism where you had to sue both the EU and the member state, was to ensure that proceedings by non-member states and individual applicants were correctly addressed as against the member state or the EU. The Court of Justice noted that if the EU or member state requested leave to intervene as a co-respondent in a case before the Strasbourg Court, they must give reasons, and the Strasbourg Court had to examine the plausibility of those reasons. There would therefore be a possibility for the Strasbourg Court to determine the plausibility of whether a given measure fell within the shared competence or the exclusive competence of the member state and the EU. And such a review would be liable to interfere with the division of powers between the EU and the member states. In other words, the Strasbourg Court would be having to rule on matters which related to the institutional autonomy of the EU. And finally, the court's reasoning on the prior involvement is a good example of jurisdictional autonomy. As the Advocate General said in that case, that the prior involvement procedure whereby you would have to seize the court in Luxembourg first as to whether or not a particular regulation was valid or not, was to enable the Court of Justice to rule on the compatibility of EU law with the Convention in a case initiated before national courts or tribunals, which had never been subject to a preliminary reference under Article 267. And that was to enable the court to pass judgment on the validity of an EU measure before its validity is challenged before the court. But there were two problems with the so-called prior involvement procedure. First, there was nothing to guarantee that it would be the court in Luxembourg that would decide whether a provision of EU law had or had not been the subject of a preliminary ruling procedure under Article 267. This was tantamount to conferring on the Strasbourg Court jurisdiction to interpret the case law of the Court of Justice. Secondly, the procedure allowed only for the court in Luxembourg to determine questions of compatibility, but it did not allow the court to determine questions of interpretation, of how you interpret legislation. However, the interpretation of a provision of EU law requires in principle a decision from the court. And to bypass this requirement was to detract from the principle that the Court of Justice has exclusive jurisdiction over the definitive interpretation of EU law. Now, you will have noted that in Opinion 213, the Court laid great stress on the preliminary reference procedure in Article 267. And I now want to turn to say something about that, because that lies really at the heart of much of the Court's reasoning in the Achmea case. As all of you know, Article 267 allows, and in the case of final courts, requires national courts to refer questions of EU law to the Court of Justice. Article 267 has been called the keystone of the EU legal order. And it does, in my view, has not only a functional element, that is to say, it allows a dialogue between national courts and the Court of Justice, but is reflective of an institutional relationship between national courts and the court in Luxembourg. And that relationship lies at the heart of the constitutional architecture of the EU. As the court put it in Opinion 213, the judicial system, as thus conceived, has as its keystone the preliminary ruling procedure provided for in Article 267, which by setting up a dialogue between one court and another, specifically between the Court of Justice and courts of the member states, has the object of securing uniform interpretation of EU law, thereby serving to ensure its consistency, its full effect, and its autonomy, as well as ultimately the particular nature of the law established by the treaties. Thus, any dispute resolution body set up by an international agreement to which the EU is a party must respect the institutional relationship laid down in Article 267. However, not all dispute resolution bodies can refer questions to the Court of Justice. The text of Article 267 refers to, and I quote, a court or tribunal of a member state. Whether a given body falls within the scope of that phrase depends on whether that body is established by law, whether it is permanent, whether its jurisdiction is compulsory, whether its procedure is adversarial, and whether it applies rules of law, and whether it is independent. And that comes from the case of Dorsch Consult. That's how the court has interpreted what is meant by a court or tribunal. The orthodox position has therefore been that arbitration tribunals do not meet this functional standard. This has very important consequences for the principle of jurisdictional autonomy. If arbitral tribunals cannot refer questions to the Court of Justice, they are outside the jurisdictional system of the EU, and this carries attendant risks for the autonomy of EU law, where arbitral tribunals interpret or may interpret EU law. Now, of course, the Court of Justice does not have to be the sole body to interpret EU law. Courts throughout the European Union, and I speak in my former capacity as a barrister in England, interpret EU law on a daily basis, and many of those cases happily never come to Luxembourg. But nevertheless, in order to ensure the uniformity of EU law, and thus its normative autonomy, it must be possible, there must be a safety valve to enable those courts at some point, if necessary, to refer questions of EU law to the court in Luxembourg. Now, the court itself has recognized that the mere fact that an arbitral tribunal applies EU law is not necessarily incompatible with the autonomy of the jurisdictional autonomy of EU law. This is because the court has accepted the compatibility of a particular arbitration award can be reviewed when a party seeks to enforce it before the national courts of a member state. And I want to illustrate this by an important case called EcoSwiss, a case decided, it's case C126/97, ECLI 1999-269. That case concerned a commercial dispute between EcoSwiss and another party, Benetton, about a trademark licensing agreement. The agreement provided all disputes were to be settled by arbitration in conformity with the rules of the Netherlands Institute of Arbitrators. The final award granted EcoSwiss damages, which Benetton sought to have set aside in the national court on the ground that the underlying agreement was void because it contravened the competition rules of the treaty. Dutch law, however, provided that an arbitration award can be annulled only on narrow grounds, including if it is contrary to public policy. The Dutch court, which referred the question to the court in Luxembourg, was of the opinion that breach of Article 101, that's the competition rule, did not necessarily entail a breach of public policy, such that it would not be possible to set aside an award which gives effect to an anti-competitive agreement. The court in Luxembourg stressed, however, that Article 101 of the treaty is a fundamental provision which is essential for the functioning of the internal market, the breach of which should therefore be considered a breach of public policy. As a result, a national court, including in this case the Dutch court, faced with an application for annulment of an arbitral award, must grant that application if it considers that award in question is in fact contrary to Article 101. Now, in that case, what the court did was to allow the national court, who was charged with enforcing the award, to ensure that the award was compatible with EU law. And as the Advocate General put it in that case, the decision not to allow arbitrators to make references for the preliminary ruling procedure under Article 267, which I've already explained, is in a sense offset by the importance the court attaches to judicial review of arbitration awards by bodies that are courts and can make a reference. And where national courts are tasked with reviewing the legality of an award in the light of EU law, this also preserves what I have called the Court of Justice's jurisdictional autonomy. Any doubt on the proper interpretation of the substantive law of the EU to the award can require a reference to the court, as was done in Echo Suisse. The court is thus content with the possibility of legality of the arbitration award being referred to them. This is what I will call soft jurisdictional autonomy. I now come to Achmea. Achmea involved an investment dispute in Slovakia. In 2004, Slovakia had opened up the domestic market and allowed operators to offer private sickness insurance services, and then with a change of government, a change of policy, and they precluded the remission of any dividends from Slovakia. Achmea, which was affected by this change of policy, sued Slovakia on the basis of a bilateral investment treaty between the Netherlands, Achmea being a Dutch company, and what is now Slovakia. The bilateral investment treaty, provided for a dispute resolution mechanism in Article 8. According to that provision, if amicable settlement was not possible, the case would be brought before an arbitral tribunal. And both the Netherlands and Slovakia were deemed to have consented to cases being brought against them in that body. And importantly, Article 8.6 of that bit provided that, and I quote, "The arbitral tribunal shall decide on the basis of the law, taking into account in particular, though not exclusively, the law in force of the contracting party concerned, other relevant agreements between the contracting parties, and the general principles of international law." The arbitral tribunal that heard that dispute sat in Frankfurt and concluded that the imposition of the ban on profits and the ban on transfer of the portfolio were measures that were self-evidently and unequivocally putting Achmea's investment in a situation that was incompatible with the most basic notions of what an investment is meant to be. So a flagrant breach of the non-discrimination provisions in the investment treaty, and that Slovakia was therefore found to have breached the undertaking to ensure fair and equitable treatment. Substantial damages were awarded in favor of Achmea. Slovakia then argued that the Article 8 that I mentioned was contrary to EU law, and it did this in the German courts where Achmea sought to enforce the award. The German court referred that question to the court in Luxembourg, and in particular, the German court asked whether Article 8, the dispute resolution provision, was compatible with Article 267 and Article 344. And just to remind those of you who may have forgotten, Article 344 provides that member states will not submit a dispute concerning the interpretation or application of the treaties to any method of settlement other than those provided for therein. When the case came to Luxembourg, the court concluded that Article 8 had an adverse effect on the autonomy of EU law and therefore could not be applied. Now, what is important here is to look at the reasoning of the court. The court began by recalling that an international agreement cannot affect the allocation of powers fixed by the treaties and hence the autonomy of the EU legal order. And that, I think, in the light of what I said in the first part of my speech, is really referring to the institutional autonomy of the EU lawgiver. The court then went on to say that the EU legal order is autonomous from the law of the member states and from international law. That is what I would call normative autonomy. The principle of autonomy is enshrined in particular in the prohibition to submit a dispute concerning the interpretation or application of treaties to any method of settlement other than those provided for in the treaties, and that is, in this case, as it was a dispute between member states, Article 344 of the treaty. And that was in order to ensure the institutional autonomy of the EU, that the treaties provided for a system of dispute resolution in that article. The court, this is the court in Luxembourg, then noted that the arbitral tribunal was required to take into account, in particular, the law in force of the contracting party concerned and other relevant agreements between the parties. There was a risk, therefore, that it would be required to judge disputes of EU law, as EU law is both the law in force in the contracting party involved, because EU law obviously is part of the law of Slovakia, and a relevant agreement between the contracting parties. And the steps in the argument, the reasoning is as follows. The first question really was, does the dispute which the arbitral tribunal is called upon to resolve are liable to relate to the interpretation or application of EU law? And the answer to that question was yes, because in deciding whether there is a breach of the BIT, the tribunal had to take account of the law in force in a contracting party. As I said, that would include EU law. The second question then was this arbitral tribunal within the judicial system of the EU? And the first question one had to consider was that arbitral tribunal a court or tribunal within the meaning of Article 267? Was it part of the system? Could it make a reference? And the answer to that was no, and this is where the court departed from the opinion of the Advocate General. The court concluded that that arbitral tribunal was not part of the judicial system of either Slovakia or the Netherlands. Indeed, the whole point of the arbitral tribunal that was set up in the BIT was that it was not part of the judicial system of those countries. Just pausing for a moment, and I don't know how many of you have following courses in international trade and investment law, but the so-called bilateral investment treaties between states that would be exporting capital, which is effectively states in the Western world, the United States, in those days, Western Europe, Japan, and states which were receiving investment, states in Africa, South America. In the early 1960s, when particularly in Africa, a lot of countries, former colonies, became independent, there was a need to incentivize Western investors to invest in those countries. There was a reluctance on the part of Western investors to invest in some of those countries because there was a concern that the judicial system in those countries was not independent, and therefore that the investment, if Coca-Cola built a $10 million factory in Argentina, and there was then a confiscation and Coca-Cola went to the Argentinian court, Coca-Cola felt that it might not get its fair day in court in a dispute between Coca-Cola and Argentina. To remedy that situation, the General Counsel of the World Bank hit on a brilliant idea, which was to provide for bilateral investment treaties between states with a dispute resolution mechanism that was removed from the courts of either state. And that had the great advantage that from the point of view of the investor, he would have the greater certainty that if something went wrong with his investment, he could appeal, he could bring his case in front of an independent tribunal of arbitrators. and also had the advantage for the investing for the country that was receiving the money, that this would act as an incentive, that it would enable Coca-Cola to say, yes, well, actually, I am going to build this plant in Argentina, and also would remove politically sensitive disputes away from the national court. So the whole system of the BITs was designed to take disputes away from where they would normally be the national courts and put them in the hands of the arbitrators. Now, if you now move back to the EU system, you can see that that, of course, is really the complete opposite of what the EU system is about, and not what Article 267 is about, because as I've been trying to explain, if you remove something from the EU system, there is a risk that you can never get the case to Luxembourg because there can be no reference. Now, I say there's a risk because, of course, we saw in the Echo Swiss case that the court accepted that the arbitrators could apply EU law because there was review at the end of the day by the national court. The question in Achmea was whether or not such review, in this case by the German court, would be sufficient to bring this system of dispute resolution within what I might call the EU family. And in this case, the court said no, it would not be. And it said so on the basis that, first of all, the award itself is under the BIT. It was said, I mean, this is Article 8.7, that the award itself is final. And although there was some degree of review of enforcement in the German courts, it was, in the court's eyes, too limited. So the conclusion in Achmea was that community law precluded Article 8, which set out such a dispute resolution principle. And they did not accept, the court did not accept that the possibility of review by the national court meant that the principle of jurisdictional autonomy is less unscathed. Now, remember that when I told you about the Echo Swiss case, I said that was a case of what we might call soft jurisdictional autonomy. Achmea is what I would call a case of hard jurisdictional autonomy. The curative powers was not enough. Now, before I close on the Achmea case, I just want to mention one last thing that the European Court said in that case. The European Court referred to earlier case law that international agreements which provide for the resolution of disputes by an international court are not in principle incompatible with EU law. And they referred to opinion 1 of 91, which I had referred to, the EFTA court, which although the court held was unlawful, the court said in principle it was not incompatible with EU law, and opinion 1 of 09, which was the setting up of the patent court. But they distinguished those cases on two bases. First of all, that the arbitral tribunal in Achmea would interpret both the agreement and EU law, and secondly, that in Achmea we were concerned with agreements that were concluded between member states and not the EU. So what lessons can we learn from these cases? First, in my view, Achmea means that the autonomy of EU law is engaged in situations where a dispute resolution mechanism might, and I stress the word might, apply or interpret EU law. Because, in fact, in the Achmea case, there was no reference in the award made by the arbitrators to EU law at all. So it's very far-reaching. Second, Achmea deals with what we might call an intra-EU BIT, that is to say a BIT, bilateral investment treaty, between two member states. The reasoning does not necessarily extend to an extra EU BIT, that's to say an agreement between Italy and Pakistan, or indeed between the EU and third countries which contain arbitral dispute resolution mechanisms in an investment section. Why do I say this? First, it must be recalled that in the ACMEA, the court relied on Article 344 of the treaty, which applies only between member states. And that, of course, 344 is an expression of what I call the institutional autonomy of the EU. Second, as I pointed out, the court referred to the possibility of submitting investment disputes to a body which is not part of the judicial system of the EU, provided for by an agreement concluded not by the EU but by member states. And third, the court explained that Article 8 of the BIT offends the principle of mutual trust between member states, that's to say Slovakia and the Netherlands, and of sincere cooperation which it applies between member states and the EU. And neither of those, of course, apply to third countries. Now, the third point is what then are the differences between ACMEA and ECO-Swiss? In ACMEA, the court could have followed ECO-Swiss and said that the BIT was compatible with the principle of autonomy because of the possibility of a national court referring a question of compatibility to the European Court. But as I've said, this was explicitly rejected and hence what I call hard jurisdictional autonomy. And what the explanation that the court gave was as follows, that while the arbitration clause in ECO-Swiss originate in the freely expressed wishes of the parties, the arbitral tribunals in BITS derive from a treaty by which member states agree to remove from the jurisdiction of their own courts, and hence from the judicial system of remedies, which the second subparagraph of Article 19 requires them to establish in fields covered by EU law, disputes which may concern the application or interpretation of EU law. Now, in my view, the key distinction between ACMEA and ECO-Swiss is what I call the institutional autonomy of EU law. And as I said, it should be recalled that the mutually independent legal relations binding the EU and its member states and the binding of its member states to each other constitutes essential characteristics of the EU legal order. Autonomy, the principle of autonomy in its numerous forms, can be compatible when two private parties agree to submit to a commercial arbitration where that arbitration can subsequently be reviewed by the national court which are part of the jurisdictional system of the EU. But the same cannot be said of a dispute resolution mechanism created between two member states who are in a relationship of mutual trust and confidence, and whose function, that's to say the dispute resolution mechanism, is to remove disputes from the ordinary courts of the EU. That flies in the face of member states being bound by common values whose jurisdictional systems insist on mutual trust and confidence. That balance of responsibility that adheres in the EU system is therefore upset by intra-EU BITs whose DRMs, dispute resolution, supplant disputes otherwise brought before the courts. Now, I'm coming to the end of my talk, but I just want to look a little bit into the future here. The question, ACMEA has raised a number of questions. The first is what is the compatibility of a DRM in an agreement to which the EU itself is party? And a very good example is the Energy Charter Treaty, the ECT. Indeed, there have been a number of arbitral tribunals seized of disputes under the ECT, and they have considered ACMEA to be inapplicable to the ECT on the basis that it is a multilateral agreement to which the EU itself is a party. And those tribunals have effectively said that ACMEA is limited to an arbitral body which is set up in an agreement between two member states, and doesn't purport to preclude the resolution of a dispute between an investor from one member state and another member state within the confines of a multilateral treaty to which the EU itself is party. In a recent case, a Norwegian investor was successful before an ECT tribunal in seeking compensation for the losses flowing from a breach of the ECT by Spain in the context of a change to the regulatory system in Spain surrounding renewable energy. That investor, the Norwegian investor, then sought to enforce that award in a Swedish court. The Swedish court has been asked to refer the case to Luxembourg on the basis that that award is contrary to what the court decided in ACMEA. A second example is a case which is pending before my court. It is opinion 1 of 17. This is a case where, and you probably know that member states and the institutions are able to seek an opinion which is binding from our court as to the compatibility of a proposed agreement with EU law. And in this case, Belgium has seized the court in Luxembourg and asked it whether the dispute resolution mechanism in Chapter 8 of the, which is the investment chapter of the Comprehensive and Economic Trade Agreement between the EU and Canada, CETA, is compatible with EU law. Now, the crux of the CETA dispute resolution mechanism is that a tribunal is set up. In fact, there's a two-tier system there, an upper and lower tribunal, and there are the following features. The CETA tribunal's jurisdiction is limited to adjudicating on alleged breaches of Chapter 8, that's the investment chapter of CETA. The tribunal has no power to determine the validity of a measure of either party and must follow the prevailing interpretation of the domestic laws of the parties. The tribunal is to apply the domestic laws of the parties as a matter of fact, not of law, and the domestic law of the parties would include both national and EU law. The interpretation of domestic law that the tribunal would reach is not binding on the parties, and the only thing that is binding are the monetary damages. Now, the question that has really arisen here, and which is a very topical question for us European citizens living in the 21st century, is the question as to whether or not and on what basis an international arbitration panel should be able to award damages to an investor arising out of national legislation which has been judged to be controversial, which has been judged to be contrary to an investment treaty. And let me just give you an example as I understand. Supposing that a Canadian company wishes to start fracking in somewhere in Italy. But it can't, it's prohibited from doing so by environmental legislation decisions which have their origin in EU law. It then brings that dispute to the CETA tribunal and says that that is a measure which is indirectly discriminatory against me, or it's a measure which is not justified on environmental or health grounds. Let us suppose that the tribunal agrees with it. It then says that the Canadian investor, I now would like my damages, which run into millions of euros or dollars. That scenario gives rise to what is known as the chilling effect. That is to say that if people are able to bring claims for large amount of damages in these sorts of cases, it may chill the legislator to act in what is perceived to the public interest. In the example I give, environmental protection. And the prospect of a damage action may have a chilling effect on such legislation. Now, I don't know how far you've got in your course on EU law, but in the context of EU law, the court, our court, has insisted on a much higher standard of liability for damages in respect of legislation, both in the case where the institutions of the EU and those of a member state violate EU law. It is not enough to show that the measure is unlawful, but you have to show that there is a sufficiently serious breach of EU law. Putting it another way, supposing that the court reaches the view that yes, there is a public health or environmental objective here, but in fact this is disproportionate because it goes just a little bit too far, should that then give rise to damages? Now, to reduce that risk in the CETA case, the CETA agreement contained provisions which preclude a finding of indirect expropriation, except in rare circumstances where the impact of a measure or series of measures is so severe in the light of its purpose that it appears manifestly excessive, non-discriminatory. And additionally, where serious concerns arise as matters of interpretation of the agreement that may affect investment, there is a joint committee which may adopt an interpretation of the agreement, which interestingly shall be binding on the tribunal established, and the joint committee may decide that an interpretation shall have binding effect from a specific date. So just pausing there, that is quite a far-reaching provision because it enables effectively the political arm of CETA, if I like, to overrule a judgment of the tribunal where they consider that it has gone too far. And the main issue that Belgium has raised in this case is whether those provisions are sufficient to guarantee the autonomy of EU law, and to what extent at all the ISDS, the dispute resolution mechanism in CETA, is distinguishable from that in ACMEA. Now, additionally, and you'll be happy to know this is the last point I'm going to make before I hope you will have some questions and comments. The other major issue that has arisen in this case concerns the independence and composition of the tribunal itself, with Article 47 of the Charter, which, as you know, requires everybody, where you're acting in the field of EU law, that you have an effective judicial remedy. Now, in brief, because I have rarely come to the end of my time, the members of those tribunals, the CETA tribunals, will not have the status of judges, but they're provisions intended to ensure that obvious conflicts of interest are avoided. The question here is whether those provisions go far enough to ensure the independence of those tribunals. Now, that is all I can say about the case. The case was heard by the Assemblée Plénière, that's to say the full court, in June, and the opinion of the Advocate General will be delivered at the end of January. May well be the subject of another seminar here, but it's not something I'm going to talk about this morning. Thank you very much.
Thank you very much indeed for your presentation, which, I mean, clearly illustrates how the ECJ played, I would say, a major role in shaping the institutional dimension of a principle of autonomy, which is, as you notice, strictly intertwined with other structural principles of EU law, sincere cooperation, the protection of EU fundamental values. and institutional balance of EU institutions, the allocation of competencies between the EU and member states, so the principle of confer, which is at the very end, I mean, the golden principle upon which the entire European integration process has been founded. So thank you very much for your presentation and also for this perspective on future developments in this area. I'm tempted to ask you if, I mean, the EU law and the case law of the European Court of Justice may actually influence the future of disputes settlement mechanism at international level. So if there is, I mean, for the EU, the possibility in this respect to trigger a change, a global change in the way in which, I mean, disputes are normally solved at international level. And maybe, I mean, before answering, if you want, it's better to open the floor to colleagues. There are colleagues of EU law, international law, tax law, and also to students, PhD candidates. So if you have some questions, some comments, please take the floor and the mic. Yeah, Giacomo Di Federico.
Thank you very much. Very, very interesting. Actually, when you quoted the passage from Qadi, I went and I double-checked again, and I'm wondering whether you don't find there as an expression of autonomy of EU law with respect to international law, what we actually find codified now in the TEU in Article 4, Paragraph 2, TEU, respect for national identities. There we find those in the first part of Paragraph 202, reference to structural principles, allocation of competences, and that is what is slowly emerging in the case law of the Court of Justice concerning Article 4, Paragraph 2. If I think of a couple of cases, Commission versus Spain, for instance, or Remondis or Digibet, and that is what is. So I was interested also in light of the opinion of Advocate General Campos in the Whiteman case, where Article 4, Paragraph 2 is recalled as a norm of equilibrium, of balance between the two autonomies, basically, autonomy of EU law and autonomy of national legal orders. And secondly, I was wondering whether what you thought, or the risk that, according to you, Protocol number 16, ECHR, can create with respect to this jurisdictional autonomy. I know it is creating, or it might create, some problems with respect to the relationship between ordinary courts and the Italian Constitutional Court in the near future. I was wondering whether this could represent a problem also from the perspective of the Court of Justice. Thank you very much.
Do you prefer to answer?
Yes, I think, yes. I think I've got two very interesting questions. Perhaps I'll deal with your question first, and I'll deal with the question from Professor Casellari. Article 4.2, respect for national identity. I sit on about somewhere between 100 and 150 cases a year. Article 4.2, respect for national identity, is invoked in very, very few cases, although, of course, in a sense, that's slightly misleading, because, of course, most of the cases that I sit on, you wouldn't have a national identity point. If it was a case about VAT or public procurement or competition law or social policy. Although social policy, interestingly enough, it has arisen, particularly in relation to some of the more recent cases that we have given judgment this year in relation to discrimination in the field of religion. Now, as you are probably aware, the court has been extremely cautious in its interpretation of 4.2, because whatever 4.2 means, it certainly, in my view, does not mean that there is any form of qualification to the principles that have been laid down by the court, starting off with direct effect, supremacy, and so forth. And in fact, if I give you an example of a recent case that I sat on, a Grand Chamber case, unfortunately the court we've now got this policy of going for anonymity of individuals' names, so it's quite difficult to remember, because being from the common law system, I remember cases by their names, but I think it's the it's Ministry of Equality. It's a case from Ireland, and it raised the question as to whether or not in Ireland, in order to implement the Equality Directive, the Irish Parliament decided that there would be a special tribunal set up to hear discrimination claims. But under the Irish Constitution, the only body in Ireland that could set aside a piece of legislation, an act of Parliament, is an Irish court, not a tribunal. And this case concerned a number of individuals who wanted to join the Irish police force, but they were precluded from doing so because they were too old. In my view, they're still pretty young, they're in their 30s, but anyway, the police course has different rules on age than for judges. And so they brought these proceedings in front of this tribunal, and they wanted the tribunal to disapply the Irish legislation, and there was a question as to whether or not the tribunal could do this, and the Irish government said absolutely not. This is our own system, and this is set out in the Irish Constitution. We are giving full effect to EU law. If you want to challenge the law, you can go to the High Court and you can get a declaration. It's just that you can't do it in the tribunal. The question came to our court, and the court ruled that that was contrary to the principle of effectiveness. It was really contrary to the principle that goes back to the extremely well-known Italian case of Simontal, decided in 1978, on a simple basis that there was no question that that tribunal was properly seized of a question of European law, namely the application of this directive, and it must therefore have all the powers available to any court to decide that, which would include setting aside any national law. So I think one has to be cautious in seeking to think that Article 4.2 is going to be in any way interpreted as undermining what I'd call the foundational blocks of the EU legal system. Coming to the Whiteman case, and I think Whiteman is very, very different, because Whiteman, the essential, Whiteman is the case on whether or not a member state has the right unilaterally to revoke a withdrawal notice under Article 50 of the TEU, and a matter on which the treaty, the TEU, is entirely silent. And the approach of the Advocate General, which was endorsed by the court, was that Article 50 was, if you like, self-contained, and the requirement for invoking Article 50 was that you had to satisfy your own constitutional requirements. And those of you who may have been following the Brexit saga for a long time may remember that there was a judgment of the United Kingdom Supreme Court in a case called Miller, where the UK court said that as a matter of UK constitutional law, the Prime Minister did not have the power herself to send an Article 50 notice in. It required an Act of Parliament. And so what the Advocate General, followed by the court, said that in the case of a revocation of a notice, it was unilateral, and the only condition was that it would be done according to the constitutional requirements of that member state. And that is really, I think, very from say, the Irish equality case that I mentioned before. Now, moving on to the very interesting question about the role of the European Union and the Court of Justice in, if you like, setting down a marker in how disputes in trade disputes should be regulated. I think this is certainly an area where the EU sees a large role for itself. First of all, as a matter of practice, I think most BITs, if you take BITs in the world, I haven't got the figures in my head, but well over 50% of BITs have been concluded between member states of the European Union. So, because obviously the European Union is a large investor, I think it's, in fact, even if you take the European Union as a whole, it is the largest investor, foreign investor in the world, even larger than the United States, and certainly than China for the moment. And there has been considerable criticism of the form of dispute resolution traditionally in BITs. And what I didn't mention in my speech, but some of you may know, is that it is the European Union's wish to move from a bilateral system of dispute resolution, so say the Netherlands, Pakistan, the Netherlands, Argentina, to a multilateral system. And so what the EU has put into the EU-Canada agreement is a expression, a desire that this tribunal, and I haven't, time doesn't permit me to go into all the features, is the first step towards the establishment of a permanent investment court, which would then apply to all agreements. So, for example, taking the EU, there have been recent agreements signed with Mexico, Vietnam, a new one I think is just about to be signed or has been signed with Japan. All of these have the same form of dispute resolution mechanism, and the idea would be to move to some form of multilateral investment system. Now, in order to achieve that, the European Union will need to seek the consent of the other major players, which obviously mean the United States, and I suspect with the current administration of the United States that we can put on the back burner for the moment, but also countries like Japan and China. And that raises the very controversial question as to the pluses and minuses of the current system of arbitration, and in particular, and I said this is something that I think you will it'll be very interesting for you to discuss next year when you have the opinion and the judgment of the court in the CETA case, as to quite what these standards should be, because, I don't want to give an overlong answer to a very interesting question, the standards of, if you like, independence of the arbitrators in what I might call traditional BITs are not those that you expect of a full-time judge. The provisions in the CETA agreement are a step towards raising the barrier on independence higher. But, for instance, one of the things that would be prohibited is what is called double hatting, whereby somebody can sit on the arbitral tribunal to hear an arbitration, and then when the arbitration is over, can actually act as counsel for, say, a member state in an arbitration. The argument is, in the CETA case, that those improvements, if I can put it that way, do not go far enough, and that even with those improvements, that the CETA tribunal does not have all the hallmarks of independence that one would expect of a full-time court. But sorry, that's been a rather long answer to the question. I think, yes, I think the EU is certainly having an impact on how these disputes will be resolved in future.
Thank you very much. I think we have, some room for other questions. Yeah, Gian Giacomo.
Thank you very much. Thank you very much, Federico. Thank you very much, Judge Vaida. I'm a tax lawyer, not European lawyer, with special attitude to European tax law. We do not have in tax law arbitration, so apparently no need to consider ACMEA and so on. But in the end, we have one procedure, sort of arbitration in tax law. We have intra-European mutual agreement procedure that is regulated by treaty between member states, not European law. And the problem, I'm quite sure, but I would like to ask you this. This mutual agreement procedure is totally a sort of black hole, we used to say in tax law. No one knows what's inside. Two tax administration meet and they settle the dispute of sharing their taxing power on intra-European situations. But it is obvious, at least in my opinion, in my view, they have to apply EU law, they have to consider EU law, and it seems obvious, in my opinion, after ACMEA, this mutual agreement procedure regulated by a treaty, not European law, it is very in danger after ACMEA and so on. And I would like to ask just a confirmation about that, about this opinion. And one more point, important perhaps. This mutual agreement procedure is not an arbitration in proper sense. Two administrations sit together to settle a sort of dispute settlement, sort of bilateral dispute settlement, but it is binding for the taxpayer, for the company involved in this, in the commercial transaction, and so the tax related to the commercial transaction. That's all. It is a sort of it is a strange sort of arbitration.
Yes, this is very interesting. Could you just perhaps explain to me, this is a arbitral arrangement between, does it involve a taxpayer and an administrator, or is it simply between tax administrations?
Okay. In first step, yeah, that's the point. That's the point, because in the first step, taxpayer is involved. Each taxpayer should confront with the two tax administration, and then the two tax administration sit together without taxpayer and to try to settle this dispute. The dispute is about the sharing of the taxing power on this transaction, this commercial transaction. For example, lots of problems related to residence and permanent establishment and sharing of taxing power between two states interested in a transaction, in income, and so on.
Sorry, just so they may then decide, say, in a case that the Italian tax authority has jurisdiction, not the Austrian, say. Is that right?
Yeah, it is right.
And is there any possibility for the taxpayer to challenge that decision?
That's the point. No, as far as I know, there is no, because this the decision in the arbitration decision is binding for each tax authorities, and it is binding for taxpayers as well. And there is no way to dispute before in front of a judge, national or European. That's according to the treaty. Huh?
Yeah, yeah. Can you? Is this working? Yes, I think it is. Well, I have to be careful what I say, because a dispute like that may arise in front of our court. But I think you are right to point out that there is a potential, I'll use a neutral word, acmea read across, in the sense that this is something which is done, which is a body which is deciding disputes between member states, which is outside the judicial system, because it looks to me, but I mean this is obviously something one have to need the detail, but it would appear that the arbitration body could not itself make a reference to the European Court, because it's not a court or tribunal. And I think from the point of view of the taxpayer, there is also a potential issue, because insofar as, and you mentioned questions of residence and this sort of thing, touches on EU law, and therefore a decision is made, say that the taxpayer is resident in Italy, not Austria, and that is something which can't be appealed by the taxpayer. There is also an issue, potential issue under the Charter of Fundamental Rights, because where member states are acting in the field of EU law, if they are in that, then in principle the Charter should apply. So I think you've raised a very interesting point, and I've just given you a couple of observations, but no more than that.
Okay, yeah, maybe we have some time. Yeah, Rosario.
Thank you. I would like to ask you about the Whiteman case. As you pointed out, the court in its holding overlapped mostly with the Advocate General. But I think it's interesting to stress that the concept of abuse, it seems to me, while the Advocate General dwelt many passages of his opinion on the danger of an abuse by member states, the court is rather soft or light in its holding. Don't you think it could lead to opportunistic behaviors by member states? Thank you.
The Advocate General said in his opinion that the question of abuse is probably overstated. Just for those of you who perhaps are not quite so familiar with what this concept of abuse is in Whiteman, the argument of the institutions was that if the decision to revoke an Article 50 notice was unilaterally in the hands of a member state, they could abuse it by effectively revoking it and then introducing a new Article 50 request. I think there are 2 points to make. First of all, both the Advocate General and the Court made it absolutely clear that for Article 50 to be revoked, a member state has to satisfy its own constitutional requirements, which in the case of the United Kingdom, which is, if you like, the member state where this arises as a matter of practice, almost certainly it would require a new Act of Parliament, because an Act of Parliament was required for the notice to be given, and without in any way prejudicing what United Kingdom judges may say, there is certainly a likelihood that an Act of Parliament would be required for the notice to be revoked. Now, in that situation, I think one has to be very careful to say that there can be an abuse, because for the European Court to say that where there's been a democratic decision taken to revoke the notice, that could be abusive, might in some sense be considered to be offensive if one considers that ultimately the European Union respects the principle of democracy and the rule of law. The second point I would make is that in any event, any question of abuse, in my mind, would not arise at the revocation stage, which, as I said, would have to satisfy the constitutional requirement, but may arise if there was a future Article 50 notice. And so, in a sense, as I said, the question of abuse at the stage of revocation is, to my mind, not a central issue, and as you say, the court didn't touch on the question of abuse in its judgment. I hope that answers your question.
Many thanks for a very topical presentation, and I have a question very strictly linked to the previous one. So, but from a very different viewpoint, and on the Weidmann case, obviously. And my question is about your personal view on the interrelationship between the principle of autonomy, I'm referring to the normative autonomy you mentioned before, and Weidmann case. And as you said, normative autonomy means basically that the validity of EU law may not rely on national or either national or international law. And but in Weidmann case, has the Commission, I think, said the effectiveness of Article 50 TEU will eventually rely on the internal situation and not only on constitutional procedures of the UK, but as far as I understand, on the political debate. And the question I see is that can Article 50 rely on very unstable or variable political debate within a member state? I do know that effectiveness doesn't mean validity. They are very different. But in practical terms, not from a juridical point, the graduation might be high. They might be stricter, I think.
Yes, I mean, I think I would make 2 points. First of all, in relation to normative autonomy means if you're interpreting a provision of EU law, whether it's a provision in the treaty or a provision of secondary legislation, that EU law is autonomous both from domestic law and international law. Now, you saw that to some extent in Weidmann itself, because you will have seen that Article 50, and indeed that is recorded in the judgment, is based to some extent on the Vienna Convention of the laws of the treaties. And indeed, if you look at the cadre juridique, the legal framework where we set out the legal provisions, you'll see right at the top international Articles 65 to 68 of the Vienna Convention. And you will see that when the court interprets what Article 50 means, it relies on the concept of autonomy, normative autonomy, saying that Article 50 is a provision of EU law, it's in the treaty, we have to give it an autonomous interpretation, which the court does by reference, classic interpretation, by reference to the text. And as you know, the text was, in a sense, and there's the word intention, which suggested that it was not, that it could be revocable, and then the object and so on and so forth. And then, and I can't remember what paragraph it is in the judgment, but sort of around paragraph 60, 65, the court says that this interpretation is corroborated by the Vienna Convention. It makes reference to the fact that in the Treaty for the Constitution of the EU, which was not adopted following a negative vote in 2 member states. It was the intention effectively to s'inspirer, to inspire oneself on the Vienna Convention. So I think what you see in Whiteman is a classic case of interpretation of EU law. Article 50, it's the first thing we do, we say this is a question of normative autonomy. We're going to look at it wording, context of the treaty as a whole, and obviously because certainly so far as the EU is concerned, the principle of democracy is absolutely fundamental to the EU, and that obviously very much colours how we interpret Article 50. There is then reference to international to say that this corroborates. On your second point, which is, well, this means that that effectively the constitutional requirements in different member states are obviously different, and that it'll depend on the political debate. I mean, that is undoubtedly true. I mean, I have no idea what the constitutional requirements are, I have to say, in any other member states. And indeed, as you've seen in the United Kingdom, which doesn't have a written constitution, in a sense, this has all been developed by the United Kingdom courts. But the point is that the treaty, Article 50, is very clear that it is subject to the constitutional arrangements of the member states. That's what the wording of the treaty says. The treaty does not say, Article 50 does not say it's subject to some European norm, and therefore the court has simply interpreted that literally, saying that is European law says that is subject to national constitutional law. And as you know, generally, when you're interpreting a provision of EU law, it has an autonomous interpretation which is separate from that under national law, unless it is expressly stated that it is by reference to national law. And Article 50 is one of those rare examples where there is express reference made to the constitutional requirements of that member state, which obviously have to be determined consistently with that by the courts of that member state. I hope that answers the question.
Yeah, maybe one last question, yeah?
Thank you, Professor Kasalari. Thank you, Judge Vajda, for interesting lecture, very informative and interesting. My name is Hirvan. I'm from Kazakhstan, Astana. I am a PhD student, and my research topic focused on the concept of judicial precedent from international and national perspectives. So, from information about this lecture, I knew that you have very huge experience and background, and you worked in the United Kingdom legal system. So my question is there some connection between the concept of judicial precedents in the United Kingdom legal system and the concept of judicial precedent from international perspective, for example, European Court of Justice? If yes, how it relates, interacted between each other? That's my question.
Thank you. Thank you very much for that question. It's often said in the member state that I come from, the United Kingdom, where many people intensely dislike the court that I'm a member of, that it's a very different court from the United Kingdom court. In fact, that is completely untrue, because any of you, and you have been reading judgments of the European Court, will see that the European Court judgments, and indeed my lecture today, have been full of citing earlier judgments. So the European system is, in fact, I regret to say this, but I will say this, it is actually a common law system. It refers to precedent. And if you look at European judgments of the Court of Justice, they read very differently from, say, if you read judgments of the, say, of a French higher court. I don't know what the position is in Italy, but it is very much judge-made law, one case at a time, and in that sense is very, very similar to the English system. And you will see that when, and indeed, Achmea is a very good example of this, because in a sense, in reaching the conclusion that the court did in Achmea, it had to deal with Echo Swiss, because effectively Achmea said, hang on a moment, this is perfectly valid. You've got the ECO-Swiss precedent. Arbitration is permissible provided you can have a review by the court. The court the result in ACME, of course, is the complete opposite of ECO-Swiss. But what the court in ACME did not overrule ECO-Swiss or did not ignore ECO-Swiss. It distinguished, what we call, the English expression is distinguished ECO-Swiss. It said actually ECO-Swiss is different from ACME. So it is very, very much a common law precedent-based system, and you will know that in very extreme cases, the European Court has actually expressly overruled previous judgments to make it clear that it is departing from previous case law. So, in fact, and I mean I can say that here in Bologna, I mean the system and the approach of the European Court is case by case. It's a system of common law precedent that we have.
So thank you really very much for your availability to discuss and for your presentation. Full of gratitude for that. And thank you also to you for attending this event. And please, if you are interested in having some more knowledge on the project, the LawTT project we are running, you can have access to our website, lawttp.eu, where all events and publications related to the project are available. Thank you very much.